Well, hi everybody. As a wee apology for running so late yesterday, thought I'd start probably about 6 minutes early. I'm sure you'll all catch up very shortly. And just to say that looking forward to next weekend when hopefully on Friday I'll have a chance to have a chat with Sharon Sunshine, our Glaswegian, about her upcoming weekend that she's put a lot of effort and work into to do with the dude. Looking forward, of course, sometime during the week to having a chat with Mill Billy whenever his work enables him to come and have a wee chat. Always good to catch up with Mill Billy. And of course, as early as tomorrow, hi Bean Green, as early as tomorrow, I'm looking forward to having our what is now become a customary weekly chat with Dr. Silkman about the lawyers and a few other things that I want to ask him about, which I will get to in a moment. But first of all, I'm not going to waste too much time. Hi Linda, and hi Jay, and hi Bob. Just want to crack on with the next part of Kathleen Zellner's motion that we looked at yesterday. This is, well, let's pop it up and let's crack on with this. And let's just look at where we got to. Hi Rachel Napstein, and here we go with the next part. Just to finish off where we left off on January the 24th, 2019. Undersigned counsel Kathleen Zellner and Mr. Richards received. Well, okay, undersigned counsel, as in Kathleen Zellner received her own copy of the September the 20th, 2011 report from the Calumet County Sheriff's Office and was able to verify the accuracy of the report provided to Miss Hagopian. Apparently it's pronounced Hagopian. Very importantly, because the state violated Wisconsin's preservation of biological evidence statute, Mr. Avery's due process rights were per se violated. His conviction cannot stand. And I like the way that she's put cannot, not just cannot is in one word, two separate words, cannot stand. And I've made a note of the couple of questions that I need to ask Dr. Silkman tomorrow. The first being that if the state, as in Norm Ghan, Wiegert, Fallon, are handing back these cremains to the Holbach family, that it's a fair assumption that these bones are indeed Teresa's. I think that's a fair assumption. Why would they be handing them back otherwise? So do we even need them to be tested? Because originally this all came about from Kathleen Zellner wanting to test these bones because these bones, cremains, should have been preserved. So is it safe to assume that these are Teresa's? I think so, yes. Do we need them tested? I don't think so. If the state say that they are Teresa's. And remember, at the time, the experts were not able to say that they were Teresa's, but the state clearly know that they're Teresa's. And if the state know that the cremains are Teresa, then it's a fair assumption that they know what happened to Teresa Holbach. These are the questions that are going through certainly my mind as regards to the handing back of these cremains. It's an admission. I think it's a fair assumption that it's an admission by the prosecution that they knew exactly that these bones were Teresa's. And if they knew that the bones were Teresa's without the DNA testing to prove that they were, if they're able to then say, we can hand these back to the Halbach family, they must know what actually happened to Teresa Halbach. I think that's a fair assumption, but maybe the doctor from Adelaide will be able to shed some light on that one. Anyway, so looking forward to a chat with him. I saw a fantastic picture of Jerry Buting, just this morning, that I want to share with everybody, which I've actually seen before in his presentation, but he made it public in a little film. Anyway, so Wisconsin statute 968-205, presumably amended in 2005 by none other than Norm Ghan, governs the preservation of physical evidence collected subject to criminal investigations. Specifically, 2, except as provided in subsection 3, if physical evidence that is in the possession of a law enforcement agency includes any biological material that was collected in connection with a criminal investigation that resulted in a criminal conviction, and the biological material is from a victim of the offence that was the subject of the criminal investigation, or may reasonably be used to incriminate or exculpate any person for the offence, the law enforcement agency shall preserve, they shall perverse justice, but they shall perverse the physical evidence until every person in custody as a result of the conviction has reached his or her discharge date. 2M, a law enforcement agency shall retain evidence to which sub 2 applies in an amount and manner sufficient to develop a, I presume that's DNA, profile, as defined in statute 939-74 from the biological material contained in or included on the evidence. Yep, I'm sure that Dr. Siltnam will be able to pronounce that word without any trouble for us. Subject to 5, a law enforcement agency may destroy evidence that includes biological material before the expiration of the time period specified in subsection 2 if all of the following apply. A, the law enforcement agency sends a notice of its intent to destroy the evidence to all persons who remain in custody as a result of the criminal conviction, and to either the attorney of record for each person in custody of the state public defender, B, no person who is notified under paragraph A does either of the following within 90 days after the date on which the person received the notice, files a motion for testing of the evidence under 97407, submits a written request for retention of the evidence to the law enforcement agency. No other provision of federal or state law requires the law enforcement agency to retain the evidence. It is beyond question that the state violated 968.205. Let me repeat that. It is beyond question. Now, I must say, I sent my yesterday's video via email to the head of the Manitrock Sheriff's Department, Daniel Hartwig, and to Mark Wiegert. I have yet to have a reply saying whether they liked it or not. I suspect they didn't, but never mind. It is beyond question. Let me just say that again. It is beyond question that the state violated 968.205 when it failed to 1, preserve the suspected human bone evidence, and 2, notify Mr. Avery and Miss, let me try and get it right again, Hagopian of its intent to do the same, because the suspected human bones were biological evidence collected in the course of the state's investigation of Mr. Avery, which ultimately led to his conviction. Additionally, The human bones were, at minimum, suspected of belonging to the victim in the crime of which Mr. Avery was convicted. But if the state are handing over these remains to the family, as I said, it's a fair assumption that they knew that they were Teresa Halbach's. How did they know that they were Teresa Halbach's without knowing what had happened to her? Because as far as the FBI were concerned, when they tried to test the bones, they were only able to make a half match. I think something like, was it 7 out of 13 loci? Okay, calm down, Paul. Therefore, the suspected human bones recovered from the Manitrock gravel pit are properly considered within the ambit of 968-205, because 968-205 does not provide a remedy for convicted persons in the event of a violation. Fashioning a remedy is left to the courts, an action Wisconsin courts have yet to take. As of this motion, no other barn pots have done what Ghan and Fallon have done. Right. As of that date, nobody had the brass neck to go and do what they did. Nobody was stupid enough to do what they did. As of this motion, there is no published opinion from a Wisconsin court that addresses a violation of 968-205. Mr. Avery submits that this court should establish the most just and most logical remedy for such evidence preservation violations, i.e., such violations amount to per se due process violations. Of course, this conclusion is borne out by controlling United States Supreme Court precedent addressing evidence preservation violations. See California versus Trombetta and Arizona versus Youngblood, State versus Greenwald. Taken together, Trombetta and Youngblood comprise the line of constitutional jurisprudence that outlines the extent of the state's duty to preserve evidence. Youngblood, Trombetta. In each case, the United States Supreme Court promulgated a test to determine whether the destruction of evidence violates a criminal defendant's due process right. The Trombetta test focuses on the probative value of the destroyed evidence and whether the evidence possessed exculpatory value that was apparent before its destruction. The Youngblood test, for its part, disregards the probative value of the evidence in favor of examining the government's role in the circumstances that led to the destruction of the evidence. If a criminal defendant can satisfy either test, then a court will rule the destruction of evidence was a violation of due process and reverse the defendant's conviction. Youngblood, Trombetta. While the US Supreme Court did not clearly state whether the Youngblood test overruled the Trombetta test, Wisconsin courts view Youngblood as a separate test that complements Trombetta. Greenwald is obviously another case. That is, Wisconsin courts determine whether the Trombetta or Youngblood tests apply in a case based upon the perceived exculpatory value of the evidence. In Greenwald, the Wisconsin Court of Appeals set forth this approach to the Youngblood and Trombetta tests after examining the differences between the tests. Because Youngblood added a bad faith determination to the Trombetta materiality inquiry, the Greenwald court reasoned that the Supreme Court intended to create two complementary preservation of evidence tests. Thus, the Greenwald court synthesized a two-part analysis to address the destruction of evidence. The outcome of this analysis depends upon two specific examinations. One, whether by looking to the facts surrounding the crime itself, the destroyed evidence was apparently exculpatory or potentially useful. And two, if the evidence is merely potentially useful, did the destruction of the evidence result from the government's bad faith? Thus, in Wisconsin, the adoption of the Trombetta or Youngblood depends upon the probative value of the evidence at issue. If the destroyed evidence is apparently exculpatory, Wisconsin courts will apply the Trombetta test. See also Youngblood, Trombetta, United States versus Ball. To invoke Trombetta, a defendant must demonstrate that the government destroyed evidence possessing an apparently exculpatory value. However, to trigger the Youngblood test, all that need be shown is that the government destroyed potentially useful evidence. Wisconsin courts have followed this line of reasoning. For example, the Court of Appeals stated in State versus Parker, a defendant's due process rights are violated by the destruction of evidence if the evidence destroyed was apparently exculpatory and of such a nature that the defendant would be unable to obtain comparable evidence by other reasonable means, or two, if the evidence was potentially exculpatory and was destroyed in bad faith. While the Trombetta and Youngblood evidence preservation doctrines originally applied only when evidence was destroyed pre-trial, the Wisconsin Court of Appeals stated that Trombetta and Youngblood and Wisconsin's two-part Greenwald test are applicable to the post-conviction destruction of evidence in Parker. There is a long line of cases addressing the pre-trial destruction of evidence and the defendant's due process rights. We see no reason why this line of cases should not apply to a post-conviction challenge to the post-conviction destruction of evidence. Mr. Avery submits that following Parker, the Greenwald two-part analysis should be applied to address the state's violation of the DNA evidence preservation statute in the instant case. When examining the test set forth in Greenwald, Wisconsin courts apply certain presumptions implicit in the DNA preservation statutes by codifying a right to the preservation and testing as provided in Wisconsin statute of evidence. The DNA preservation statutes create three presumptions regarding both the materiality of the evidence and the circumstances surrounding its destruction or loss. And we'll just hold it there. I think that's enough for now. You know, there's going to be a new, Stephen Avery is going to set a new standard, and that is something that, as I say, that's never been seen before. Let's go back to that paragraph. It was stunning. As of this motion, there is no published opinion for a Wisconsin court that addresses a violation of. This case is going to establish a new precedent, and that is what happens when the state, and particularly the prosecutor who was part of the team that amended the statute, decide to go against the very rules that they've established. But folks, is that not what we've seen all along? They're quite happy to tell everybody else what to do, do as I say, not as I do. Anyway, I'm just going to finish off very quickly, as I say. If you missed the start, it was just to say that looking forward to having a chat with Sharon Sunshine on Friday evening, my time, to do with the weekend and all the work that Sharon's put in to collecting a whole load of the dude's videos, which is going to be great. Looking forward to, obviously, hopefully having a chat with Millbilly whenever his work allows. And obviously tomorrow, looking forward to a chat with Dr. Siltman. And it's funny, it was just by reading through this opinion, which I hadn't read for, a year and a half. And it reminded me of my thoughts at the time, and I've written them down. These are questions that I want particularly answered. And you know, a DNA expert such as Dr. Siltman, he's the ideal one to ask. By handing back these cremains to the holdbacks, that to me is an admission that these cremains are Teresa Holdbach's. Do we even need these bones tested? That was what sparked this all off, of course, was that Kathleen Zellner wanted these bones to be tested. And of course, that's when she found out. And I believe it was Carol Ann Fitzgerald over there in Australia, in Sydney, in Australia, who pointed out, well, no, you surely know that the state have already handed them back. Kathleen Zellner's like, no, I didn't know about this. My report is minus the last 2 pages. But do we really need the bones to be tested? If the state are handing back these bones to the Holdbach family, that I think it's a fair assumption they know that they are Teresa Holdbach's. And I think then that it's a fair assumption that if law enforcement know that these bones are Teresa's, and the experts were unable to say that they were, if law enforcement know that they are Teresa Holdbach's, that's because they know what happened to her. I think that's a perfectly fair assumption. Anyway, looking forward to, as I say, having a chat with the good doctor tomorrow morning my time, about 11 o'clock my time, which is about 8 o'clock in the evening for Australia. Anyway, I'm going to say cheerio because I've not got much time left on my StreamYard Live. The good thing is that if I was to do a live with like 5 minutes to go of my 20-hour maximum, they would not, and I've tested this in the past, they would not just cut your video. They would, as long as you start within the 20 hours, your last video, you could go on for several hours. But well, I'm not planning on doing that anyway. Keep it nice and short. Gives me time to save my energy for the next video to rant and rave at this this blatant corruption. I think what it reminds me of when I first got in touch with Herman, and I couldn't believe that he was trying to defend what we'd just seen, and I think he kind of realized. Well, I know he kind of realized. You know, Sheriff Herman. You know, I'm not a young kid. I've been on this planet a long time. I'm older than you. Don't try and give me your BS. I ain't buying it. And eventually he got to realize, no, I was not going to buy his BS. I remember the time he told me about the, he said, you do realize that, although there were several searches of Stephen's trailer, some of them were only like sweeps, and I said, Sheriff Herman, Robert, I can tell by the embarrassment in your voice. But that's it. They just don't want to accept the fact that of course they don't want to accept the fact that they were wrong, because then the question is, why did you get it wrong? Because there was something more to it than simply getting it wrong. You got it wrong for a reason, and we all know what that reason was. It's the fact that you couldn't handle the embarrassment of Stephen Avery being held up as this hero, and you lot all stuck together. It's the thing that you do, of course. You all stick together. And as far as the state was concerned, they were prepared to do anything to avoid the embarrassment. And I think that's going to be the shocking thing, is when people in Monitrock realize, they finally wake up and realize just what it was that the law enforcement in Monitrock, in Calumet, at Peg's office, just the lengths to which they're prepared to go to, as they would consider it, to preserve, to save anybody in law enforcement from any embarrassment. It's quite shocking. Anyway, I'm going to say cheerio, we're going to hopefully see the good Dr. Silkman tomorrow morning, and I appreciate that a lot of Americans will be fast asleep at that time, enjoying another Packers win. So catch up with us later on. Okay, we'll see you all later. Bye for now.